Welcome back, dear students. Today we will learn what is a writ of mandamus under our constitution. Dear students, we have already learned that there are 5 kinds of writs available under our constitution, and mandamus is one of them. What is the meaning of writ of mandamus? The writ of mandamus is a judicial remedy in the form of an order from a superior court to any government body, court, corporation, or public authority to do or not to do. It is a mandate positively as well as negatively to do or not to do some specific act that the government body, court, corporation, or public authority are bound to perform or not to perform under law, as the case may be. Mandamus, dear students, it means court can ask common people, authorities to do or not to do some task. It does not lie against the president, governor, parliament, state legislature, private bodies, and individual persons. This writ is not applicable against the constitutional authorities like President of India, Governor of the state, Parliament, state legislatures, private bodies, and individual persons also. This writ is not applicable against individual persons also. Dear students, so far as the purpose of mandamus is concerned, the primary purpose of this writ is to make the government machinery work properly. An order of mandamus is a command directed to any person, corporation, or an inferior tribunal requiring them to do some particular thing which pertains to their office and which is in the nature of a public duty. Simply put, the mandamus is a writ issued by a superior court commanding the performance of a specified official act or duty. So, dear students, this writ of mandamus is also called as a writ of mandate, and it is a court order issued by a judge at a petitioner's request compelling any government, corporation, or public authority to execute a duty that they are legally obliged to complete. A writ of mandamus can also be issued when the authority of a higher court is required to order a lower court or government agency to complete a duty to uphold the law or to correct an abuse of discretion. The writ of mandamus can be used to order a task to be completed, or in other cases, it may require an activity to be ceased. A writ of mandamus is acquired through a petition to the court. You will have to file a petition to the court for asking a writ of mandamus. Then, dear students, there are certain key takeaway points regarding mandamus. And the first point is that a writ of mandamus is a court order compelling someone to execute a duty that they are legally obliged to complete. Second takeaway point is a writ of mandamus is also used to order a lower court or government agency to complete a duty to uphold the law or to correct an abuse of discretion. Third takeaway point is that in general, a writ of mandamus is a written command in the name of a court or other legal authority to act or abstain from acting in some way. Next point is that writ of mandamus are unique. Why? Because they can be made without completing the full judicial process or before a case has concluded. And the fifth takeaway point is that a writ of mandamus is deemed necessary when the action or inaction of the government bodies or corporate officials are so inappropriate and wrong that immediate emergency action needs to be taken by the legal system. Dear students, if you analyze the writ of mandamus, there are three categories of mandamus. One is a alternative mandamus. An alternative mandamus is issued as the first step in the writ of mandamus process. The alternative mandamus commands the defendant to perform the act demanded or appear in court to explain the reason for not performing it. Basically, it requires that a person to show cause that they should not be made to perform the act. Take one illustration. I am a pensioner. I am getting pension from Government Department of State of UP because I retired as district and sessions judge. I am getting my pension from Treasury Office, Gautam Buddha Nagar. Now suppose the Treasury Officer of Gautam Buddha Nagar has stopped my pension without any reason. Although he has a public duty to release my pension on 1st of every month. Now he has stopped my pension without assigning any reason. So I will file a writ of mandamus in the High Court of Judicature at Allahabad. And on the day one, when I have filed a writ, maybe that alternative mandamus is granted to me as a first step. Show cause notice is issued to Treasury Officer Gautam Buddha Nagar to show cause as to why he should not be made to perform the act, why he should not release my pension on 1st of every month. So this is alternative mandamus order, which is issued in the beginning of the writ. The moment writ is filed, alternate mandamus may be issued in the form of a stay order or an injunction order or a command. Then comes peremptory mandamus, that is a final mandamus. A peremptory mandamus is issued when the defendant fails to prove sufficient reason for not performing the act in question to comply with alternative mandamus. If alternative mandamus is not complied with and Treasury officer could not show sufficient reason as to why he has stopped my pension, a final order will be issued against him. So peremptory mandamus is a final order of a court and an absolute command to the defendant to complete the act in question immediately. When the defendant fails to show sufficient cause in an answer to an alternative mandamus, they are issued this formal written command in the shape of final mandamus. Now suppose initially a show cause notice was issued to Treasury Officer Gautam Buddha Nagar. He could not give sufficient reason as to why he had stopped my pension, and final mandamus order was issued against him from Allahabad High Court. Now suppose after 3 months or 6 months, again he stops my pension. Then third mandamus, which is to be issued against Treasury Officer, will be a continuing mandamus. Here the court will have a supervisory role. In a writ of mandamus, even after the court has given the directions, the matter is not disposed of. And at this point, court assumes a supervisory role. While the writ remains pending, the court may make continual order to ensure that the government, corporation, or public authority in question remains compliant. Remains compliant means that Treasury Officer Gautam Buddha Nagar will comply the orders of the court in future also. So a continuing mandamus refers to the enforcement of a court direction within a specified period of time. So dear students, we can bifurcate mandamus into three parts. Alternate mandamus in the beginning, final mandamus, final order, and then continuous supervisory role of the court under the heading of continuous mandamus, so that the treasury officer of Gautam Buddha Nagar may not disregard the order of the High Court. The High Court will keep on fixing dates after 6 months to 6 months or year to year and will supervise whether the treasury officer is regularly issuing my pension on monthly basis or not. So this is the third part of mandamus, which is known as continuing maintenance. So dear students, these were the important points while understanding the meaning of mandamus and its three parts. And the most important point which you must learn, that in India, the mandatory condition or the sine qua non for mandamus is the existence of a statutory public duty incumbent upon the person or body against whom the mandamus is sought. There must be a statutory public duty, and there must equally coexist a corresponding right in the petitioner, entitling him to claim the enforcement of such public duty. Like Treasury Officer of Gautam Buddha Nagar is under statutory public duty to release my pension on monthly basis on 1st of every month. And I have a coexisting corresponding right to receive the pension. So right in favor of petitioner and statutory public duty on the part of the authorities or the government or the treasury officer is essential for issue of the writ of mandamus. So these two preconditions, they form the foundation for the issue of mandamus. And the primary scope and function of mandamus is to command and execute rather than inquire and adjudicate. The High Court or Supreme Court will not make an inquiry into that, will not adjudicate upon the matter, but they will command and will see that their orders are executed. And it cannot be issued to change the decision of a body so as to suit the petitioner. No. Obligations which are not of statutory nature cannot be enforced by mandamus, meaning thereby that duty of the officer, duty of the government must be a statutory public duty. So dear students, this writ of mandamus is again not maintainable when a remedy is provided under Code of Civil Procedure. For example, High Court cannot entertain a writ petition for mandamus to the government who fails to deposit and pay in the requisite time an enhanced compensation as ordered by a lower court. The petitioners in such cases would be directed to approach the executing court for appropriate relief. Suppose government has awarded me compensation while acquiring my land and they are not paying my compensation. So I will have to approach the executing court. I will have to approach the office of district magistrate so that compensation may be paid to me. And dear students, only Supreme Court, that is the apex court, and all high courts are empowered to exercise writ jurisdiction under Article 32 and 226 of our Constitution. No other courts are empowered to issue this writ. Only the high courts and the apex court. No other court is empowered to exercise this writ jurisdiction. So dear students, now I will tell you the various features of a writ of mandamus. And the first and foremost feature is that mandamus is a judicial remedy in the form of an order. And this writ cannot be issued to compel an authority to do something against the statutory provisions. Against the provisions of law, against the provisions of law, you cannot command or say to any lower authority that this work is to be done, for the simple reason that doing of that something was against the law, against the statutory provision. And dear students, this writ of mandamus is most remedial in nature, and its purpose is to remedy defects of justice. It may be issued where there is a specific legal right, but no specific remedy is available for its enforcement of that right. So when it will be issued? It will be issued when there is a specific legal right, but no specific remedy is available. I have a legal right to receive my pension, but the treasury officer is not listening to me. He has stopped my pension. No other remedy is available to me. Then I will go to the High Court and file a writ of mandamus. So no one can ask for a mandamus without a legal right. One must have a legal right before he can ask for mandamus. And as I told you in the beginning of this lecture, that mandamus is not only a command to do, but also a command not to do a particular thing against the right of the petitioner. Second feature is that applicant must show that he has a legal right to compel the performance of some duty cast upon the opponent. I have a legal right to receive the pension. Treasury officer has public duty. Treasury officer has the public duty to sanction. Hello, good morning. So this duty must be a duty of public nature. Hence, this writ cannot be issued for enforcement of obligations arising out of a contract. If there is a contract between A and B and there is a breach of contract, that is a personal obligation, private obligation. The obligation is not of a public nature. So writ cannot be issued for enforcement of obligations arising out of a contract. We have an illustration. CIT versus State of Madras. A contract was entered into between the petitioner and the government, and there was a breach of contract on the part of the government. So writ of mandamus was refused by the court since no performance of public duty was involved. Secondly, this duty on the part of the public officer must be imperative and not discretionary one, because the mandamus will lie to compel the performance of an absolute duty. We have an illustration. Vikram Narayan Singh versus Government of UP. In this case, there was a duty cast upon the Deputy Commissioner to pay pension to the petitioner. It was held that it was open to the applicant to enforce this duty through a writ of mandamus. The example of pension I gave you earlier also. Then we have Dwarika Prasad versus State of UP also. In this case, it was held that a mandamus can be issued to a public authority to restrain it from acting under a law which has been declared unconstitutional. If a particular law has been declared unconstitutional, so it is not to be enforced. So mandamus can be issued to a public authority to restrain it from acting under a law which has been declared unconstitutional. Here is an illustration. In this case, which I read before you, according to Section 4, Clause 3 of UP Coal Control Order 1953, this section was declared as void, being violative of freedom of trade and business guaranteed under Article 19(1)(f) of our Constitution, as it imposed unreasonable restrictions on this fundamental right, and the restrictions imposed were not reasonable. In this case, under this Section 4, Clause 3, the licensing authority is given absolute power to grant or to refuse to grant or to renew or refuse to renew or suspend or revoke, cancel or modify any license. And these powers could be exercised by any person to whom the state controller may choose to delegate the same. Such a provision was held not to be reasonable, as it affects the fundamental right of trade and business of retail seller of a coal. I am a retail seller of the coal and you have cancelled my license without showing any reason. You have delegated the power of cancellation and delegated officer has cancelled my license. Now I cannot do retail business as seller of the coal. So it affects my fundamental right of freedom of trade and business. So a mandatory directions were issued not to enforce Section 4, Clause 3 of UP Control Order 1953 because the same has been declared void and unconstitutional. Then, dear students, if with the public officer duty is discretionary, then no mandamus will lie wherever the duty is discretionary in nature. We have an example of State of MP versus GC Mandawar, case decided by the Supreme Court, wherein it was held that under Rule 44 of Fundamental Rules, the grant of dearness allowance at a particular rate was a matter of grace and not a matter of right. Hence, a writ of mandamus against the government was held to be not justified. All of you know that public servants, their salary structure is framed like this, that they have a basic pay and then dearness allowance is also granted to them. But dearness allowance is granted by the government as a matter of grace. The public servants do not have a right. Government do not have a duty to grant dearness allowance. It is in their discretion to grant or not to grant the dearness allowance. So whenever the duty is discretionary, mandamus will not lie. Then, dear students, another feature is that no mandamus against private persons. Mandamus will not lie for an order for reinstatement to an office which is essentially of a private character. No public duty is involved because the matter is between two private persons. On this also, we have a leading case of Praga Tool Corporations versus C.A. Emmanuel. And dear students, it's not that you can claim mandamus at any point of time. If your petition is unduly delayed, then relief of mandamus can be refused because the delay defeats equity. There is unreasonable delay, or if during hearing there is a tribal issue on the basis of limitation is raised by the respondent and court thinks that, well, this point of limitation is a tribal issue, still the mandamus shall be refused because you went to the court with much delay. Then, dear students, for issue of mandamus, demand and refusal is also necessary. Suppose I am removed from my services and I have filed a writ in the High Court, writ of mandamus. I never applied to the head of the department for my reinstatement. He never refused to reinstate me, but still I have directly filed the writ of mandamus in the High Court. So High Court will not grant me a relief unless I make a demand before the proper officer and that officer refuses my relief. Only and only then I have a cause of action of filing a writ of mandamus. The leading case is Naubat Rai versus Union of India. The petitioner was in the service of military form department and he was removed from the service. He applied for a writ of mandamus in the Punjab High Court, but it was not shown that he had applied for reinstatement or that he even applied under the rules against order of the removal, and such demand was denied. Hence, writ of mandamus was not maintainable because no demand, no refusal was there. Then, dear students, while exercising writ jurisdiction, the High Court or Supreme Court is not acting as a court of appeal. Court will not act as a court of appeal while sitting as a writ court and will not examine the impugned order on merits. But the writ court will interfere in case of illegal exercise of discretion, where the impugned order is made without jurisdiction or in excess of jurisdiction, or is made malafidely, or if authority is influenced by extraneous considerations, then writ of mandamus will lie. And dear students, I told you in the beginning that no mandamus can be issued against legislatures. A writ of mandamus cannot be issued to a state legislature to prevent it from considering a bill which is alleged to be in violation of Constitution of India. No court can issue a writ to the legislature to enact or not to enact a particular law. You see, Kisan Andolan is going on in Delhi. Even Supreme Court cannot issue a writ of mandamus to the government not to enforce the 3 bills relating to Kisan Andolan. No, it cannot be done. And similarly, dear students, the mandamus cannot be issued for ultra vires act. Mandamus is generally issued to restrain an administrative authority from merely committing an ultra vires act. Likewise, it can be issued to prevent government from enforcing an unconstitutional or unconstitutional acts or notifications. So, ultra vires acts can be controlled through mandamus. And the last point is that no mandamus against high constitutional authorities. A writ of mandamus will not lie against President of India for fixing the strength of judges in the high courts and filling of the vacancies. No, you cannot direct the President of India that he should fill the vacancies quickly. He should increase the strength of the judges in the High Court or Supreme Court. This was held in S.P. Gupta versus Union of India in 1982. Then lastly, dear students, we have 2 very important mandamus cases. Vishakha versus State of Rajasthan. In this case, Supreme Court issued detailed guidelines for protection of women against sexual harassment at workplaces, exercising its writ jurisdiction while issuing mandamus. And D.K. Basu versus State of West Bengal, in which case the Supreme Court issued detailed guidelines for arrest of accused persons in a writ of mandamus. So these 2 important leading cases reflect the scope of mandamus writ petition. It is not only issue of mandatory commands to do or not to do something, but even guidelines can be issued for protection of women against sexual harassment at workplaces, and directions can be issued regarding arrest of accused persons. So, my dear students, why this directions in the absence of law are covered under writ jurisdiction? Because the word in Article 32 Clause 2 is, and 226 also, that court has power to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari. So words in the nature of mandamus are important. It's not only the mandamus which can be issued, but orders in the nature of mandamus can be issued. So these guidelines of Vishakha, guidelines of D.K. Basu, they are in the nature of mandamus. They are not exactly mandamus, but the Supreme Court and various high courts are empowered to issue guidelines in the nature of mandamus also. So, dear students, I think now the concept is clear to you. Thank you very much.